Welcome to The Breach Show, featuring sharp analysis on politics and social movements in Canada. I'm your host, Desmond Cole. A referendum asking if Alberta should separate from Canada hit a major roadblock last week. A judge in that province ruled, among other things, that the government failed to consult First Nations about the petition calling for a referendum. Alberta Premier Danielle Smith is pressing on, saying she'll appeal the court's decision. What can we learn from this clash between provincial separatism and First Nations treaty obligations? Joining me to discuss all this is Matt Wildcat, a member of the Ermineskin Cree Nation and an assistant professor and the director of Indigenous governance in the Faculty of Native Studies at the University of Alberta. Welcome to the show, Matt.
Yeah, thanks, Desmond. I'm happy to be here with you.
Likewise. And as we get started, just a reminder to our audiences to please like and subscribe if you want more bold journalism for transformation. Matt, there is a lot to discuss, and I want to start with the broader Alberta separatist movement itself. Mm-hmm. We know that this movement isn't new. Ever since, 1980, when Pierre Elliott Trudeau enacted the National Energy Program and sought to control more of Alberta's oil, separatism has been an undercurrent for many Albertans. But as this movement exists today, what does it tell us about how Canadians understand ownership of the lands that they're on?
Mm-hmm. I don't want to give too much credence to the separatist movement, but I will say there is some diversity of thinking about treaty rights and Aboriginal rights within the movement, right? And so you have someone like, Bruce Pardy wrote a Substack in the fall. There was some reporting from Danielle Paredes on it, which was really good. And Bruce's position is essentially the same position that Canada held up until the 1970s, which is that a policy of assimilation, that Aboriginal people would no longer exist as distinct political and legal entities in the country, right? And and he lays out that the rule of law should be based on equality between peoples, and that there should be no distinction in how the law applies to everyone, right? It's hard to know how widespread that position is within the Alberta separatist movement, but it's not a unified movement, right? It has multiple centers of power within it, multiple points of influence, and so certainly there's an assimilationist bent within it. But you also have someone like Jeffrey Rath, who's been, although it's a very kind of troubled history, but has been a lawyer for First Nations on many different files before, and has a real understanding of Aboriginal and treaty rights. And so someone like Jeffrey Rath has said that even under an independent Alberta, there would actually be room for First Nations to continue their relationship with the Crown, right? And so these treaties signed between the British Crown and First Nations would persist, and that Alberta would negotiate its role, an independent Alberta would negotiate its role and all that. I don't know what that looks like, but this is the claim that he's made. Also in January, when Athabasca Chipewyan and the Blackfoot Nations launched their court case, and Sturgeon Lake had a separate one that got treated somewhat separately. You had a spokesperson from the Alberta Prosperity Project. I came out and said, one of the ways in which we could deal with this is that First Nations reserves would remain part of Canada. So if Alberta was to separate, First Nations reserves would stay as part of Canada, and we would figure it out from there. So what strikes me about them is they're never concerned about having a dialogue with Indigenous peoples, right? So it's always about what the separatist movement thinks would be beneficial for Indigenous peoples, or even an understanding of what First Nations people deserve from their perspective, right? But that's not Indigenous people's understanding of treaties. I think the simplest way to describe Indigenous people's understanding of treaties from the standpoint of it being a relationship or a partnership is what treaties are meant to do is to figure out how we live on the land together, how we share the land in order to ensure mutual flourishing, right? And so the groundwork of treaties is meant to ensure mutual flourishing between both parties in perpetuity, forever, right? And until something else comes along.
That's a very helpful overview. Mm-hmm. Now, apart from how separatist movements and First Nations and Indigenous people more broadly may view these treaty obligations, the courts have obviously also spoken, and including this recent decision that we
Hmm.
saw about whether or not this referendum can go ahead as planned. And the courts have also spoken about obviously separatism in places like Quebec, where this has obviously
Hmm.
come up before. In your understanding, broadly, what have courts said in the past about separation and Indigenous treaty rights?
Yeah. So this is a really interesting question. So we have from the late 90s the Quebec secession reference, and this asks, what was put to the Supreme Court was, is separation legal? Like, can it occur, and can it occur under Canadian law, and can it occur under international law? The short answer of what the court said is that this is beyond what we can rule on it. And so what the court said is that if there was a clear vote, um, what should happen is that it compels all the parties to come to the table under the duty to negotiate. It creates a legal obligation on all the parties to negotiate, this duty to negotiate. And the court was mostly interested in washing its hands, like of not being involved. And the court wanted to draw a line where it thinks of separation as a political issue rather than a legal issue, right? And so it pushes us back to political leaders to figure out the terms of what would happen. So between the secession reference, I feel like it happened in 96 or 97, just shortly after the 1995 Quebec referendum. So, this is 30 years of jurisprudence has happened. And in 96, 97, the duty to consult had not been defined by the Canadian court system, right? I believe it was the Haida Court case in the early 2000s, 2003 or 4, where the duty to consult was really outlined in Canadian law. And so this is built on a number of, like really going back to the 1973 Calder decision, 30, 40 years of legal reasoning in Canada where Aboriginal rights are defined. The Canadian court starts to think about, is there any way in which Aboriginal rights can be infringed upon? How are they to be protected or infringed upon? And then the duty to consult comes about to try to put some definition around, okay, when the Crown or Canadian governments make decisions that might infringe on Aboriginal rights, what obligations do they owe to Indigenous peoples in that instance? How must they consult Indigenous peoples, right? So it actually doesn't, like Canadian, the Canadian state can still infringe upon Aboriginal rights, but they have to justify it.
Understood. Now, when we come to this particular ruling from last week, Justice Shayna Leonard said that the process didn't have the proper amount of consultation of First Nations leading up to this referendum. In your understanding, Matt, what kind of consultation with First Nations was supposed to happen in the lead up to this October referendum that did not happen?
Yeah, well, there's zero consultation, so that that makes it very easy for the judge in this instance, right? And so the separatist movement has made an assumption, or maybe has hoped that consulting with Aboriginal peoples can occur after a positive referendum vote. So I think what they were hoping is that it could be a secondary issue which gets dealt with afterwards. I think there's quite an awareness within the separatist movement that it will have to be dealt with in some sort of way. But I wonder if there was a bit of a hope that, if you had a positive separation vote, that they're obviously in a better position of leverage, right? Like there's been so the other big piece in the Canadian law is the Clarity Act from the late 90s, which laid out details through which a secession question could be asked. And it says there has to be a clear question posed to a group of people, right? And so I think what flows from that is that, or part of the Clarity Act rather, is that if there's a clear expression of will on behalf of a people of a province, that it sets in motion all of these discussions that then have to occur, these political discussions where people have to figure it out. The Clarity Act is also very clear, even though it predates the duty to consult, that Aboriginal people must be consulted if there was, a clear expression of will on behalf of a people of a province, to want to secede from Canada. But yeah, I suspect that the separatist movement was hoping to do that from a position of strength, because I'm at this point, it's pretty obvious that the position of First Nations is that there should be no secession question ever. Like there should never be, we should never even consider it. There's no ability to think about it. And so politically, First Nations have been unanimous in saying this is illegal. And then there's been some work to lay out from an Indigenous legal standpoint with the legality of secession. And here, so you have someone like Leroy Littlebear saying, who has laid out for us, well, Indigenous people's understanding of property is that, humans can't have full, dominion over land because we share the land with plants and animals. And so as First Nations people, when we made treaties with newcomers, what we were doing is we were making an agreement to share the land, which we then had to share with other aspects of the natural world, right? And so there's no way to further divide it up, because we would have to then bring into consideration our relationships with the natural world into these deliberations. And so until all of that was dealt with, there would be no ability to further divide jurisdiction over the land. And so you can see how unless you had, like, I think from an Indigenous legal standpoint, the only way in which you could have separation is a ground up like overwhelming consensus amongst both Indigenous and non-Indigenous peoples to change jurisdictional boundaries, and that this overwhelming consensus would have to be listened to because that was the will of the people, right? But like a truly kind of transformational mindset, I think, is the only way within Indigenous legal thinking that a secession could occur, and we're far, far away from that.
It's just so interesting because I think it presents a situation which we see in Canadian politics and law a lot, where Indigenous peoples who don't think that this process even should be happening nevertheless have to essentially hope that courts like this one are going to rule in a way that is favorable to them and that allows more collaboration and conversations like you're talking about to continue, because otherwise there's a possibility to just get legally steamrolled by a process that you don't consent to.
Totally, yeah. And so, so going back to this ruling, it's done a very specific thing, which is prevent the ratification of this petition that's gone around, right? So there's no ability for the Chief Electoral Officer of Alberta to go and assess the veracity of the 300,000 signatures that have been collected. And then as such, that prevents the petition from going forward to an actual vote. The Alberta government can still call a vote. And in fact, I have heard that Premier Smith is planning a major press conference for tomorrow, and in fact may call a vote anyways. There's the possibility, as I heard suggested, that this vote will actually be the vote from the Forever Canada petition led by Thomas Lukaszuk, which asks if people want to remain in Canada. The conference I was at yesterday, held by the Center for Constitutional Studies at the University of Alberta. Someone suggested you rarely have a referendum to affirm the status quo, right? Referendums are typically done in order to seek a transformation or a change in society in some sort of manner. And so, there's a very real possibility that if we had a referendum around should Canada or should Alberta remain part of Canada, that it actually might, the Clarity Act might kick in, and the federal government might intervene and say, this will muddy the waters if we're asking people to affirm the status quo. Like, what is the purpose? What is the point of that? It also gives, frankly, is to the advantage of the separatist movement, because they get two kicks at the can, right? So they get to test out what people might think about that question, and then they might still go and press to have an actual vote on separation. And so it's, just having the Forever Canada vote is not necessarily a good thing for First Nations people and for other Albertans and Canadians too, because this will have impacts for the rest of Canada also, right? For Alberta to leave.
What you're saying here about Danielle Smith potentially calling this press conference tomorrow, we're gonna have to stay monitoring this. There aren't going to be many boring days, it sounds like, coming up in your province anytime soon. But let's talk a little bit more about Premier Danielle Smith, because she did say that she plans to appeal this ruling
Yeah.
that says no petition can be accepted, as does the group Stay Free Alberta, who collected the signatures demanding the referendum in the first place. There's
Yes.
this really interesting interplay, Matt, between Premier Smith, who claims that she does not support separation outright, and Stay Free Alberta, who are obviously campaigning on it. How do
Hmm.
you see this relationship and this interplay between the premier and this group?
Yeah. So, for the political the political wonks out there. So State Free Alberta is essentially an arm of the Alberta Prosperity Project, which is, probably has become the most organized of all the separatist groups. And so that this Stay Free Alberta, they had to because there was some policy reason why it couldn't be the Alberta Prosperity Project, which led the petition itself, but they're essentially overlapping groups. So, the leaders of the Alberta Prosperity Project and also of the separatist movement at large have called on people to join the UCP party, and part of that joining of the UCP party is to exert influence and as a show of organization to try to in a shadow way control the party. So
Of course, this is Premier Smith's ruling party in Alberta, just
that's
for
right,
our
the
audience.
United
Yes.
Conservative Party. Yes, thank you.
Yes. Yes.
And so one of the really interesting things is when the Quebec referendums were brought, they were brought by the Parti Québécois, and the Parti Québécois campaigned in a provincial election on having a separation vote, right? And so there was already a popular expression of will that there was, that people wanted, to have a referendum on secession. And so within Alberta, the United Conservative Party did not campaign on this. And in fact, Premier Danielle Smith, when she first came in, she replaced Jason Kenney near the end of his term, right, in the middle of his office. And then when she ran, a general election, she did not campaign on separation. This is, so this is it's distinct from Quebec in those aspects, right? So what a lot of people have compared Danielle Smith to is in fact the position that she's in within within Alberta is the Brexit movement and the way in which David Cameron initiated the Brexit vote, right? And so there you had within the conservative tent in Britain a group of people refer to them as Eurosceptics, people who wanted to see Britain leave the European Union, and then you had a more moderate wing of the Conservative Party, and so David Cameron felt, you know what, if we just like put this question out to the open, get it over with, the Eurosceptics can complain and articulate their views and and try to bring people over to their side. Surely they're going to lose because the polling actually looked very similar to what it looks like in Alberta. Only like kind of 30% of Britain's population actually wanted to leave the European Union. But as we know from David Cameron calling for this referendum to when the vote actually happened, they were able to pick up all the additional 20% of the popular vote that they needed in order to trigger a series of events which led to Britain leaving the European Union. And so will that happen in Alberta? Probably not. I think at the end of the day, it's incredibly unlikely that a popular vote will occur, which causes Alberta to to leave the country. And so even though I have a great deal of urgency around responding to this problem, I don't want to be anxious about it either, because I think at the end of the day, there needs to be a bit of self-confidence that things will almost certainly remain as they are. And so what is possible for it to happen, rather, is that a vote could see that percentage of Albertans who express a desire to leave Canada, which is hovering around 25 to 30%, potentially look like 35 or 40% under a popular vote if the leave campaign, or seeing an independent Alberta, the leave vote be get enlarged through the process, right? And that is very possible. You don't know who runs a better campaign. So sometimes it's easier for campaigns to really stoke fears and anxieties in people, which could cause people to migrate towards wanting to see an independent Alberta. I also, one of the I hate to use a sports analogy here, but it's not a 7-game series, right? It's a single vote, and so you might also just have a really bad week. If it was a best of 7, I'd feel very, very confident that over the course of 7 referendum votes, that people would certainly want to stay in Canada. But you never, on a single day, you never know what kind of shifts will happen in people's opinion because of critical events leading up to an event, and so so all of these things they put Danielle Smith in a position where the primary part of her base really wants to cause this referendum vote to happen, and she needs to appease them in some sort of way in order to remain in power. At the same point, in order to keep the United Conservative Party together, she can't become an outright separatist party, because it will probably cause somewhere from 20 to maybe even more 40, maybe even 50% of her party to leave and to form a different political party.
You've engaged all of our Montreal Canadiens fans with your 7-game series comparisons there. Sticking with Premier Smith for a minute, she did something I think a little sneaky in reaction to the court decision, which was that she said that it was unfair of the court to expect a citizens group like Stay Free Alberta to have to consult with First Nations. She said, quote, "I have no idea how the court would expect a citizens group to be able to meet the duty to consult that was just made up in that judgment," unquote. But that's not exactly what the court said, is it, Matt?
That's actually I haven't heard that before, and I'm gonna have to go look at her position there. So I'm assuming that the court said that it's the responsibility of the Alberta government to lead the duty to consult. Is that correct? Or
that was my understanding.
Yes,
I was curious if that was yours also, because I thought that was such a weird statement from the premier.
Absolutely, and I think this is where a little bit we're kind of making things up as we go, right? So it's one of the ways in which Danielle Smith has walked this tightrope of wanting to appease her separatist base while also wanting to keep her, the United Conservative Party together as a whole, to not fully alienate people who are not separatists within her party, is that she's made this a matter of procedural fairness, right? The point of all of these legislative changes that they've made in order to make it easier for a citizen-led referendum to occur is a matter of procedural fairness. We live in a representative democracy where there's some assumption that when you vote, members of the Legislative Assembly in Alberta or members of Parliament, or when you vote for representatives, that they have the responsibility then to lead legislative and political changes, and so Danielle Smith has been really keen on direct democracy, that the best, the most just way of running a democracy is you directly poll people on issues of importance to them, right? So again, there is there's kind of these all unique elements of Alberta separation, because typically when a government is putting forward a position, it's because they believe in that policy position. They believe that this is the right thing to do, and then they're asking the wider population, the wider citizenry, are we correct? Are we getting it right? But in this instance, that's not what's happening. They're saying, well, actually, Danielle Smith's line is, I believe in sovereign Alberta within United Canada, and she really sticks to it. She's kind of gone away from it a little bit more recently, but this is kind of her position. And so if we take her at face value there, why is she making all of these moves in order to what seems to cause a separation referendum?
Well, right. It's as if she's saying, I don't necessarily believe in the proposal, but I believe to the death in everyone's right to make the proposal.
That's right.
And she's going even further than that by suggesting, and I want to get your feedback on this too, Danielle Smith actually said after the ruling that she may use the notwithstanding clause to get around it. And of course, that clause allows provinces to temporarily bypass charter rights. Matt, I've read several legal experts who say that the notwithstanding clause does not apply to this situation. Do you have a view on that?
So I don't. It's a little bit beyond my legal reading or my legal expertise in this situation to understand the kind of the legal reasoning behind why the duty to consult would apply in this situation. But what she can do is she can make a cabinet order to cause a referendum, and she can, so one of the things we might hear tomorrow is that the referendum is going to happen. It's going to happen on October 19th, where she's already laid out these kind of like 9 questions, largely around immigration, which takes these like really awful, and it has all of these. They're just such leading questions that would cause an uncritical observer to think that people who are coming to Alberta are taking advantage of all of our systems, right? And so, we have all of these anti-immigrant questions already on the ballot for October 19th. And then everyone's belief is that she'll round it. There's 9 of them. She'll round it out to make an even 10. And the last question will be on Alberta separation. So she could do that through an order in cabinet. And then what would be required is the Alberta government would be required to then lead the duty to consult with First Nations.
I think it's worth mentioning also, as you talk about all the proposals for immigration on this referendum in October, that Danielle Smith actually wanted to substantially increase immigration only a few years ago. Like, that was her push. And now she has done a complete reversal, presumably because of popular opinion and immigration falling out of favor in Canada. I want to ask you about the fact that even as Premier Smith is fighting for this separatism vote, she's also been partnering with Mark Carney, as we saw recently, to keep moving forward this plan for a new pipeline to the Pacific Ocean. Given the opposition to such proposals from many First Nations in British Columbia, where this pipeline has to go through, do you see this evolving pipeline plan between Carney and Smith as another potential confrontation on Indigenous treaty rights?
Yes, no, almost certainly. And, part of the way in which that's going to play out is that you can't be suing somebody over one thing and then try to be their business partner on another. Like that is just common sense, right? And obviously in Alberta there's many First Nations which are pro oil and gas development, and in order for the TMX to get built, they had to generate a fair amount of support and legitimacy within. I'll qualify this. I mean, not within First Nations at large, but within the elected leadership of First Nations, right? And so, that was a lot of work that was done, even though there's still kind of, I think, widespread skepticism amongst First Nations people for a lot of these developments. And, it's hard to know how you can have a policy position where you're trying to fight against climate change on the one hand, and then on the other hand be building pipelines, right? Like there has to be some significant efforts to want to reduce our dependency on oil and gas moving forward. And so, for all of these reasons, I think, First Nations people are, as a whole, are skeptical. But, at the end of the day, if the elected leadership people who are, authorized to speak on behalf of First Nations, there was a lot of work done to bring people on board and to, in order to get the TMX built. I don't see any way in which this pipeline is going across northern BC. I just think the amount of resistance that is up there to another oil and gas pipeline would be impossible. And so even if you had some support in Alberta, it would be impossible in BC. But, even let's say you just increase the capacity along the existing TMX, the Trans Mountain Pipeline route, where you already have, some buy-in from First Nations. Why would First Nations in Alberta agree to go along with something when you're actively trying to deny our rights through the use of the Notwithstanding clause in another realm of our relationship, right? It just is, it's an indication that there is really very little consideration that Danielle Smith makes about Indigenous peoples. And she's really done this all the way along from her early statement where she compared the treatment that Alberta receives from the federal government to the treatment that First Nations receive under the Indian Act, which is a federal piece of legislation. And so you can just see all the way along. She had another kind of what I found to be an outrageous statement around First Nations and our early settlers and First Nations taming a shared frontier. And I was like, no, the frontier was a term you used to denote space that was controlled by white people, by white settlers from space that was still controlled by Indigenous peoples. And so, all the way along, there's just been very little attention paid to First Nations. I found it so shocking because under the progressive conservative governments, led by Ralph Klein and the Progressive Conservative Party, which ruled for I think 40 years or well over 30 years, for well over a decade, you had a First Nations person who was the Minister of Aboriginal Affairs for the province. Like, you had a deep amount of knowledge within previous governments of First Nations people, and so it seems like such a walk back of if not policy, at least knowledge and understanding of First Nations in the province.
I want to end with this, Matt. Rob Lyon wrote a really interesting piece for Marxist.ca where he said that there are basically two Western alienations among Canadians in Alberta. One Western alienation would be from the corporate elite who want bigger profits, they want fewer taxes, they want fewer regulations on industry. But then the other alienation that Rob Lyon described was of the working class. People who feel like they're not getting the services that they should be having in Alberta, that they're not getting the environmental protections or the political influence that people in Alberta deserve with Ottawa. And I wonder, do you see any future potential for collaboration among working class Canadians in Alberta and First Nations, who also have, obviously, as we've been talking about this whole conversation, their own historical and present day grievances with provincial and federal governments? Can these groups find a way to forge a common political agenda together? And if so, how might that happen? I know it's a huge question, but
no, it is. I love the question. Actually, I was thinking about this a little bit yesterday. So you've seen from often very upper middle class, well educated, progressive Albertans, this kind of grabbing onto treaty as a life, vest in some sort of way during this time. Like, we cannot possibly separate because the treaties make it impossible to separate, right? And so you have this, I think a very progressive, wealthy, educated aspect, or part of the Alberta population who is really thought of as First Nation, or really thought of First Nations as being saviors in this instance, right? From this kind of emboldened separatist movement. But if people are really believing that, then it has to cut both ways. Like, First Nations can't just be used instrumentally in this situation to maintain the status quo of Canada. If you really believe in treaties, then what you believe in is that we're partners who are trying to share the land together in order to ensure mutual flourishing. But if people are really believe in this idea of mutual flourishing, part of what has to happen is then we have to discuss the terms of what mutual flourishing means, right? And that necessarily gets into questions of the economy, and it starts to ask big questions like, okay, how do we define wealth and how do we produce it, right? How do we labor over our creation of wealth in this country, and how do we distribute it? So all of these questions around creating wealth in order to ensure mutual flourishing are not just the obvious questions around, like, having a huge GDP or being able to, like, see return on investments and all of these things. They get down to fundamental questions of how do we even define wealth to begin with, and how do we produce it and arrange its goods, right? And how do we labor and how do we distribute over wealth? And if we want to be really serious then about being treaty partners to ensure mutual flourishing, it means that Indigenous peoples have to have a substantive say in generating a shared understanding of what it does mean to create mutual flourishing. So I think that, yes, ultimately there probably is the ability for labor and for other people who are not necessarily advantaged in society, to find a common cause and to create what I won't say the goal is to create a shared identity, but I think there has to be points of shared understandings, right? And so I do think all of those things are possible, but I think we know that they're really not easy, and that we still have big questions, other structural questions around how issues of race and gender and colonialism also shape the way in which people can have conversations and generate shared understandings with each other. And we're, unfortunately, it feels like we've been set back a little bit from centering questions of race and gender and colonialism within our discussions over the last few years due to the pushback on wokeness. But I think obviously those questions are going away, and I believe that we have the capacity over time to be creative in finding ways to help people talk across difference and to work together across difference. Because at the end of the day, I think ultimately all people have higher level principles within them, and it's just a matter of finding ways to pull out those higher level principles around wanting to live in a world where we believe we treat each other well, and that we can take care of each other.
Matt, we were hoping for a stimulating discussion on these issues, and you have not disappointed us. Thank you so much for joining us and sharing your insights today.
Awesome. Thanks, Desmond.
If you like what you've heard on The Breach Show, please subscribe to the podcast. And if you would like to support our work, please become a sustaining member to help us produce more journalism for transformation. And you can do that by going to breachmedia.ca/support. Thanks for listening.